At Tad Nelson and Associates, we handle intoxication manslaughter cases. Of all the DWI cases, this is the most serious one. Punishable by 2 years to 20 years in the penitentiary. It is also a probationable offense. Let me tell you a little bit about what intox manslaughter is. It's a DWI that results in a death. So how do we get from DWI to intox manslaughter? You have a couple things here. Number one, the government has to prove there's a DWI case so that the person that's accused of the crime is actually intoxicated. The second thing they have to prove is that but for that intoxication, this death would have not taken place. So there has to be a causal relationship. That's what makes this case interesting. So they've got to attack on two fronts. Number one, they have to prove intoxication. So they're either going to have to prove, just like a typical DWI first, there's going to be the loss of mental or physical faculties, or an alcohol or a blood level of over 0.08. So the second issue becomes, did that intoxication cause the accident which ultimately caused the death? And that's where these cases take all the work, because these cases can either be fought at guilt innocence, when you're trying to either say my client's not intoxicated or my client's intoxication did not cause the accident, because not every accident that a person that's intoxicated is in is caused by them. Sometimes the other car can actually cause the accident. And in that case, that's one that you would have to evaluate for, is there the causal relationship between the two? The second way you would fight these cases is when you do have, I've had several of these cases where there's little doubt that my client was intoxicated, little doubt that the intoxication caused the accident. Ultimately, on those, it becomes a punishment issue. We just finished one in Harris County. The offer from the government was 14 years in the penitentiary. My client was a young girl in her 20s, was driving her best friend, who just happened to be a guy, and they were driving along. They'd gone out that night. They were driving down a slick road. They ultimately slid off the road, hit a tree, and unfortunately, her best friend passed away. The government, in this case, wanted 14 years. So in that case, there was no way that we could win on the evidence to get a not guilty. Clearly, her blood was 3 times the legal limit. Her driving was ridiculous. Here's what the government can do. There's so many of these chips in cars that they can actually tell, what the car was doing before the collision. In this particular case, on a wet road through a neighborhood with some kind of a zigzagging road, car was going up to 95 miles an hour. By the time it slid off the road, it was probably only going 70. Obviously, in those situations, nobody's going to drive 95 miles an hour on the wet, on the slick. Obviously, that wasn't a guilt innocence issue. So in this case, and a lot of these cases they become punishment cases. And in that case, you literally have to go to the jury and pretty much beg for your client's life. And you ask me, how do we do that? How do we show a jury that a client is worth not sending to the penitentiary? Here's how you do it. You bring in everybody that knows them. You bring in family, friends, people that work with them, and you show that, hey, this behavior was an aberration. This is not who this person is. This is a good person. And I'll tell you, it's tough. It's a really tough case, because while you're saying how good a person your client is, and how, while I'm telling the jury what a great person my client is, the government is bringing in the family of the victim, the deceased, and saying what a good person that is. And that's just how it happens. Ultimately, you have to make the pitch to the jury that your client is worth saving. And I'll tell you another thing. What we can kind of talk about with juries, and we talk about it a little bit in voir dire, that a judge can punish that person up to 180 days in jail as a condition of that probation that you're begging the jury for. More times than not, and I can tell you, of the last 5 cases that I've gotten probation for where my client was clearly guilty, where we've got a jury to give probation, the judge is always going to come back and unfortunately put the person in jail for 180 days. It's just standard operating procedure for these judges, especially Republican judges. They're going to give them 180 days in the county as a condition of that probation. They are getting punished, but so many of these people are good people. This is the first thing they've done wrong, the only thing they've ever done wrong, and there is no reason they should ever see one day in the penitentiary. And if you have a case like this, if you want to come talk to us, if you need somebody to fight to keep you out of the penitentiary, that's what we do at my office. Come see us at Tad Nelson and Associates. We're here to help you.